Okay.
May it please the court, counselor. My name is Sharon Proctor. I represent the appellant, Dale Williams. I'd like to reserve 5 minutes for rebuttal if I can contain myself to that amount. The trial court committed 2 reversible errors in this product liability case involving a defective power saw that injured the plaintiff's right hand. First, the trial court erred by allowing the defendant Lowe's to introduce evidence that the plaintiff had recovered a personal injury judgment in a prior unrelated lawsuit that was brought 9 years earlier. Second, the trial court abused its discretion by denying a motion for mistrial when evidence came in that the plaintiff had been addicted to crack cocaine.
Was that a subject of the motion in limine that was previously filed before trial?
The first error was the first evidence related to the prior lawsuit was the subject of a motion in limine. The evidence about the addiction to crack cocaine was not a subject of a motion in limine, and in fact the plaintiff's counsel was surprised by that evidence. That evidence was not ever listed as a trial exhibit. And
was an objection lodged at the time the evidence came out?
There was no objection made when the question was asked. There was a motion for mistrial following that testimony while the jury was recessed.
If there was no objection made at the time the testimony came out or at the time the question was asked, does that preserve your right to move for mistrial later?
Yes, Your Honor. The right, pardon me?
Go ahead.
The right to move for mistrial is always there, and the First District Court of Appeal addressed a similar situation.
To have a mistrial granted, do you first have to timely object to the evidence coming in, or is an objection unnecessary?
An objection is unnecessary to move for mistrial. If the court determines
then
that...
I guess my next question is, does the motion for mistrial have to be made at the time or soon after the evidence is presented that's the subject of the motion for mistrial?
It should be made soon after, and the sooner the better. But it need not be made in the next breath or even during the testimony. There are a number of cases...
When was the motion made in this case?
In this case, the motion was made at the conclusion of the testimony by the witness when that evidence came out. The next time that the jury was dismissed and the plaintiff's counsel had an opportunity to speak to the judge outside the presence of the jury, counsel moved for mistrial. It was before the jury was charged. It was before the jury was sent back to deliberate. And there are a number of cases that hold that a motion for mistrial that comes before the jury is charged or dismissed to deliberate is timely. In a somewhat similar...
Counselor, are you familiar with Dorsey versus Reddy, a decision out of this court last year?
I'm not familiar with that, Your Honor. Could you educate me about that?
Let me read you one paragraph from it that I read yesterday. To provide a trial court with the opportunity to correct errors, a timely objection is necessary. The court in McGowan, an earlier second district case, applied this rule in a situation similar to that here. It concluded plaintiffs had not timely moved for mistrial because they failed to make a contemporaneous objection to testimony during the defense's case in chief. Rather, they moved for mistrial on the day after the objectionable comments were made. The motion for mistrial here was similarly untimely, and so forth. It seems to me that this court is already on record standing for the proposition that in cases such as this, where there is surprise testimony or other objectionable testimony, you must give the trial court an opportunity at the time the comments are made to correct the situation, and that delaying until the following day is insufficient. Now, I don't know of any cases that we have that say differently. Do you?
Your Honor, first just let me distinguish briefly. This was not done the following day. It was done the same day that the testimony came in, as soon as that testimony had concluded. And I'm not aware of a case from this court addressing that. The First District Court of Appeal in White addressed a situation where improper comments were made in an opening statement. There were 4 opening statements by 4 different attorneys in that case, 4 parties. And the attorney moved for mistrial at the conclusion of all 4 opening statements once the jury was out of the room. And what the First District Court of Appeals said is that because the trial court treated that motion for mistrial as timely and ruled upon it, that the same purpose of a contemporaneous objection had been satisfied. That's exactly what happened here. When plaintiff's attorney did in fact move for mistrial on the basis of the evidence of crack cocaine addiction, as well as the cumulative evidence about the prior litigation, the amount of the judgment obtained in that litigation, and so on, the trial judge ruled on that motion for mistrial as a timely motion.
I thought that motion came the following day.
I don't believe so, Your Honor. My recollection, I'll double check, I have the transcript with me. My recollection is that it came as soon as that testimony had concluded at the next time that the court and counsel were in court outside the presence of the jury.
See, it seems to, as I recall that testimony, or as I recall the motion, it was the attorney sort of indicated that he was kind of struck dumb by the testimony. He didn't expect it, and so he didn't really know quite where to go with that. And then he finally decided a little later on that it was objectionable and needed to be a motion needed to be made. But I thought that was the following day. I wish you would check that.
I will check that, Your Honor. And perhaps counsel remembers, but my recollection is it's that same day, that same immediately following, basically, when they're discussing it after that witness had testified, and not the following day.
It's my understanding that a curative instruction was given by the judge on that issue, correct?
Yes, Your Honor.
And that is normally a discretionary decision by the trial judge, correct?
Certainly it's to the trial judge's discretion whether or not to give a curative instruction. In this case, plaintiff's counsel was very clear that he did not believe that the taint created by the drug addiction testimony in conjunction with, didn't you get a lot of money from a prior personal injury lawsuit, and why haven't you used that money to pay your doctor, that those 2 things together were so prejudicial that that taint could not be removed.
Well, here's my concern. Normally it's discretionary with the trial judge whether it justifies a mistrial or simply a curative instruction, and the standard is generally whether it's so prejudicial that the curative instruction is not enough. It seems to me that issue relates also, however, to this issue about the contemporary objection. That if it is so offensive that it can't be cured by a curative instruction, that points out one of the problems with, I don't object at the time, I let the answer be given, and then we visit it later on down the road, and that's when I ask for the mistrial. If the answer is so prejudicial that it's not going to be cured by a curative instruction and requiring a motion for a mistrial, why doesn't that same argument compel the lawyer to object at the time, because it is so prejudicial? It seems to me it's almost, it's almost invited in the sense that you're going to let them answer it, but the answer is so prejudicial that it can not then be cured, and you're going to set up the mistrial. If you're that concerned about the prejudice, why shouldn't the objection come contemporaneously before the answer is given?
Certainly an objection should come contemporaneously, and it's better if it comes contemporaneously. But the issue about whether or not a curative instruction is sufficient to cure that prejudice, that's a question for the trial court. In fact, that goes all the way to fundamental error. One of the definitions of fundamental error is error that could not be cured even if an instruction were given. This court explained that concept in the Walt Disney case by saying that you can throw a skunk in the jury box and tell the jurors not to smell it, but that doesn't do any good. There are a number of cases that say drug abuse as well as prior criminal activity is the type of information that is so prejudicial that a curative instruction cannot remove that taint.
Ordinarily, I might agree with you, but this was a situation where I think the defense was attempting to demonstrate that damages were really quite limited, and that the reason your client was taking Percocet and other drugs was not so much because he was in pain, but because he had a drug habit. And so there is at least some minimal connectivity between, I mean, I agree with you, first of all. I think it was unfair for defense counsel to start in on the crack cocaine addiction business. I think that was wrong. But there is some relevance to it. And I guess I'm having a hard time with, as Judge Palmer indicated, I'm having a hard time seeing where that becomes so egregious under these facts that a curative instruction was not appropriate.
Your Honor, the curative instruction that was given, if anything, made it worse here. And the reason that it was so prejudicial is exactly what Your Honor has pointed out. This plaintiff had a crack cocaine addiction when he was 14. At the time of trial, he's in his 30s. And there's no evidence whatsoever, other than this improper insinuation, that he's taking Percocet because of an addiction. Yet that's exactly what Defendant Lowe's argued to the jury. He's not really hurt. He's looking for an excuse to get prescription medicine. And the jury, having heard that he had this history of crack cocaine addiction, and the judge said something along the lines of, you should ignore the fact that the plaintiff is a crack cocaine addict. Rather
it wasn't
than,
quite that bad.
it was almost that bad, and the point being, that's the reason that raising an objection at the time would have actually made it worse. And
Actually, what happened? I went back and looked. What happened was after that, there was no objection at the time the comment was made. Trial counsel for the plaintiff then conducted a redirect. Everybody rested. And there was the motions for directed verdict were made and denied by the defense. And at that point, after essentially the conclusion of the plaintiff's case, at that point was the first time the motion for mistrial comes out. I don't know if it was the same day or not, but it was substantially later.
That's correct, Your Honor. It's at the time that they're resting, they're discussing issues that need to be taken up at that time. The trial judge said, I quote, this is at page 434, "During the trial, you heard evidence of the plaintiff's addiction to crack cocaine. I'm going to instruct you to disregard that evidence." Not particularly helpful in terms of...
Was there an objection to that?
Removing yes, sir, there was an objection that no curative instruction could possibly...
Was there an objection to that specific language?
To the wording. No, there was not an objection to the wording. There was twice stated on the record by plaintiff's counsel that no curative instruction would be enough given these facts. And there was, of course, regardless of the timing on the motion for mistrial, there was the motion in limine with respect to the previous litigation and excluding reference to that, which the trial court denied. And as a result of that...
Denied without prejudice to raise it on a question-by-question basis, correct?
That's correct, Your Honor. And a motion in limine is always without prejudice for the plaintiff to stand up at trial and object. The purpose of moving in limine is to prevent the question being asked in the first place, and the question then giving the type of information to the jury that you're trying to prevent that prejudicial, unfairly prejudicial information from coming in. Here, the question itself was a very long, convoluted question, something along the lines of, isn't that in fact what you testified to about your other injury and your 1995 injury and your 1995 lawsuit? Didn't you testify that, and so on. So by the time an objection comes there, the jury's already heard what you were trying to prevent the jury from hearing by moving in limine. And that's the reason that the Florida Supreme Court adopted...
Well, and the purported relevance was what? That there was a prior injury?
The purported...
That created some of the pain and suffering?
Plaintiff had no objection to the prior injury evidence coming in. The plaintiff's motion in limine was directed solely to the prior litigation. And the defense argued that the prior litigation was relevant because the plaintiff testified that he had been unable or was unable to afford to pay his doctor. The second district...
What was the relevance of that? Why would the plaintiff be able to testify to that?
None. There was no relevance.
But the plaintiff did testify to that?
In response to defense questions. You haven't paid your doctor, have you? You don't care if your doctor gets paid, do you? And in fact, the argument that Lowe's made as to why this was relevant was because he answered, no, I haven't paid my doctor because I can't afford to pay my doctor.
Were there
So-
objections made to those questions when the questions were asked?
No, Your Honor, that was part of the motion in limine that was raised before those
Yeah,
questions
but the
were asked.
the end result of the motion in limine was that the trial judge, who was it, Judge Cemento? The trial judge said, make those objections on a question-by-question basis, so that
The trial judge did say that. The trial judge also said, I'll deny the motion to exclude any reference to a prior suit and a jury trial.
Yeah.
I agree with the defense. So the defense argued it's relevant because he says he can't afford to pay, and yet he got all this money 10 years ago in another personal injury suit. So it's relevant to rebut his testimony and show that he's not credible, because in fact he should be able to afford to pay since he won this judgment 10 years ago.
What do you make of the fact that the plaintiff's counsel then on redirect specifically explored those whole issues of prior recovery?
Well, if you're asking if that's invited error or something along those lines,
I guess what I'm asking is, what are we to make of that?
I think what you make of that is that the plaintiff was put in one of those Hobson's choice. The evidence has now come in. I asked the court to keep it out. The court denied my motion in limine, and now that it's in front of the jury, I have to do what I can to try to minimize the prejudicial effect of that. Your Honors, I see I have a little under 4 minutes left. If there are no more immediate questions, I'd like to reserve my remaining time for rebuttal, please.
May it please the court, my name is Jamie Bellotti Moses from Fisher Rushmore in Orlando. I'm here on behalf of Lowe's Home Centers. Yes, Judge Monaco, it appears that the motion was made after a break. I believe the judge said we'll come back in a few, and then the first statement on the record after the break is there anything else? And he brings up the motion for mistrial. It did come up, however, after completion of the testimony, both parties resting, motions for a directed verdict and a break. And I don't believe it was the next day because it was only a 2-day trial.
Do you agree, Ms. Moses, that it was sharp practice for defense counsel to introduce both of these subjects that are the subject matter of this appeal at that trial?
What type of practice, sharp or shoddy?
Sharp. Well, either one. You take your choice.
Well, actually, I somewhat disagree with Ms. Proctor, who I've never had the privilege of meeting before because she's out of state, but the focus of this trial was not to prove that this was some bad drug addict. That was not the way, and if you reread the openings and the closings, that was not the issue in the case.
There was no reason to bring out the testimony about this man's prior drug addiction when he was 14 years old, other than to inflame the jury.
I know that my trial counsel would respectfully disagree with
Well,
you.
he might respectfully disagree, and I have a hard time understanding
you wouldn't?
how a curative instruction regarding something that prejudicial would take away the unfairness of that testimony coming before the jury.
The issue,
Especially when it's connected with the fact that not only did they bring out the fact there was a prior lawsuit, they brought out the fact of how much money he got and the recovery.
but actually, Mr. Faddis, trial counsel, took an opportunity to explain and ask plaintiff what he actually received, and he said, I wished I had seen $166,000. I didn't. I was going through a divorce.
You know as well as I do that even if for whatever reason the testimony of a prior lawsuit comes in, you don't bring out the amount of the recovery and let the jury know that, do you?
I agree with you that there's case law that says that the amount may not be relevant in some cases. I believe that appellant's trying to tell you all that it's per se reversible error for that type of information to come out. We have here unobjected to questions, and this wasn't, I mean, there was an
Are you referring now to the prior litigation or to the drug addiction?
I'm on the prior litigation because you said the amount is not relevant.
Well, there was a motion in limine. I understand that your opposing counsel indicated there was a motion in limine and the trial judge denied that. Do they then have to get up and object every time the question comes up?
Yes, when a trial judge says to you, I'm going to deny the motion right now, I want to take it up on a question-by-question basis, then in my opinion, and that of the case law, I think, is that, yes, you need to bring it up again. How many times does trial counsel say, I'm not going to rule on this issue right now, let me see it in the context of the trial? Unless it's a clear slam dunk motion in limine.
You don't think that a motion in limine asking the trial judge to prohibit testimony of the prior litigation coming in, and the trial judge denies that and says bring it up on a case-by-case basis, would be enough to cover the fact that it was the testimony regarding how much this man actually recovered wouldn't be sufficient to preserve that objection as well?
No, sir, I don't think it's enough, because you're supposed to give the court an opportunity to correct themselves, right?
The trial judge has an absolute out then, doesn't he, or she? When a motion in limine is filed by saying, well, I'll deny the motion in limine, but we'll take it up on a case-by-case basis, which essentially means that there's really no ruling and the motion in limine is basically meaningless.
Well, I don't think trial judges are looking for absolute outs. If anyone had an out...
Isn't that essentially what happens when a trial judge does that? I mean, there's an absolute out. I mean, the motion in limine is basically rendered meaningless because the trial judge says, I'll deny it, but we'll take it up on a case-by-case, question-by-question basis.
I do not believe that a trial judge has an out in that instance. All the judge is saying is, you presented argument A, defense counsel presented argument B. Right now, out of the context of the questions in the trial, I am not going to rule on the motion in limine. All he can do, I mean, if he grants it, nothing comes in. If he doesn't grant it, it comes in, and defense counsel should object at the appropriate time, or plaintiff's counsel should have objected at the appropriate time.
There's absolutely no value to the motion in limine in terms of preserving their objections later on in the trial. That purpose of filing a motion in limine is entirely vitiated because the trial judge says, well, I'll deny it, but we'll take it up on a question-by-question basis. I mean, that it essentially vitiates any purpose in filing a motion in limine in terms of preserving the objections for later on in the trial.
I simply disagree. It doesn't.
Then how is it preserved?
Because there was an opportunity to object if the question was truly objectionable. Instead, we have no objection, and then on recross, I think 13 or 14 questions about it.
You misunderstand. My question to you is, one of the purposes in filing a motion in limine is to get the objection before the trial judge so they don't have to stand up and continue to object later on in the trial. That's one of the purposes of it, isn't it?
Correct.
All right. And if the trial judge says, well, I'll deny it, we'll take it up on a question-by-question basis, that vitiates the purpose of filing that motion.
Well, and there's nothing wrong with objecting. There were only 4 in this trial. It's not like Mr. Faddis thought there were going to be a bazillion issues that he was constantly going to be standing up on, and this was just one he wanted to get out of the way.
I have one other question for you.
Yes,
we
sir.
have improper testimony introduced in a trial, not only concerning the fact this man had a prior litigation concerning personal injury, but how much his recovery was. That, in addition to the fact that some maybe 15 or 20 or some odd years later, in the past, when this person was 14 years old, was a drug addict, and that comes out to the jury. Explain to me how a curative instruction is going to take care of the taint to the jury when they've already heard the objectional testimony about the fact this man had a recovery in a personal injury case, and then on top of that, he's a drug addict. How is a curative instruction going to take care of that and remove the taint from the jury?
I do not think there's a taint from the prior litigation. Mr. Williams himself testified, I didn't get hardly anything, and I used it to live off of. I don't see how that tainted the jury, and I know.
You don't think that the amount of prior recovery coming out and being introduced to the jury is prejudicial? Why would the courts ban it then and say it's testimony that doesn't need to be presented?
Well, I think if you look at the case law that's been cited, there's been prior litigation has been brought out for a purpose. In one case, it was to prove that she'd filed 15 other lawsuits. In another case, it was to prove a different issue. In this case, it was because every time Mr. Williams saw a subsequent doctor, he complained about his back, not his right finger.
Right, and you can bring out the fact in a personal injury lawsuit, the fact that this man has had a prior injury, and that this is the damages that he's complaining about now are not caused by the accident, they're caused by the prior injury. But that doesn't give you leave to come in and not only bring out the fact he had a prior lawsuit, but the amount of the recovery, does it?
Well,
that's how you take care of that.
And there should have been an objection. If it's that bad, why didn't you, I mean,
Well, I have a
counsel
problem.
objects.
Here's my problem, is that they filed a motion in limine, the trial judge denied the motion, and then said, well, we'll take it up on a question-by-question basis. I have a tendency to think that the objection was preserved when the motion was filed and the trial court denied it.
Okay, and if you do feel it's preserved, I would go to the next step, with which the trial court did not abuse its discretion in denying the post-trial motions. The trial judge is in the best position to know if this truly tainted the jury. And one thing that's not being discussed here because of these two issues is the fact that the plaintiff's story changed during the litigation. When he filed the complaint, he had made 3 cuts. By the time his expert reviewed the case and said, I don't think 3 cuts is going to cut it, for lack of a better expression, it became, I did a lot more work and then it fell apart on me. The plausibility of how this happened was refuted by plaintiff's own expert and the saw itself.
I have a couple more questions. The evidence came out about the fact that this fellow was addicted to drugs when he was 14 years old. There was no objection. Does an objection, a contemporaneous objection, need to be made at that time in order to preserve your right to request a mistrial later on in the trial? In other words, is a contemporaneous objection a predicate to the motion of mistrial?
It's a contemporaneous objection.
Predicate to a granting of a motion for mistrial?
It's a contemporaneous objection. I thought it was, but the way you're asking the question makes me want to second guess.
Okay, well, maybe I don't want to ask any unfair questions, so I think you get my drift. You have to object contemporaneously in order to establish a basis for granting a mistrial later.
I think the judge's review on when the trial court is deciding whether I should grant a mistrial or not is different when it's been objected to. Because if you object and it's sustained, then you move for a mistrial. The judge's analysis is going to be different than if you don't object, it gets in, you question your own client about it, and then you move for a mistrial. Okay?
Well,
because then it's basically got to be fundamental error. The judge has to say, you know what, even if you objected, even if I sustained it, or even if I gave a curative instruction, it was still so harmful, you're entitled to a mistrial.
When was the motion for mistrial? I think you said it was made. Actually, I'm confused as to when it was made now. Do you know when the motion for mistrial was made?
I will explain. The motion in limine was before.
I know that.
No, I know. I'm not being condescending. I'm just saying, the motion in limine about prior litigation was before. The motion for mistrial was after the questioning of the plaintiff, after the parties rested, after the defendant moved for a directed verdict, after the court said we'll take a recess and come back. Then they came back, they had taken a 10-minute...
And at what point in time, after the improper testimony had been elicited, what would be the cutoff point in terms of making the motion for mistrial in this particular case? When would too much time have elapsed?
Your Honor, I can't. I mean, I think definitely if there were 3 more days of trial, I think that's way outside the range.
You're contending that their motion was not timely made?
No, you can move for mistrial at any time, so I'm not going to suggest that the motion was untimely. I think it's unfair to say here that the trial court abused its discretion in denying the motion for mistrial after sitting through this entire trial and being hit with a line of questioning that wasn't even objected to. And the judge says, you know what? Just to be safe, I'll give a curative instruction. It was not, you need to disregard that this guy was a crack addict. It was said, you need to disregard the testimony about it. The judge is in the best position...
Is that why the trial judge denied the motion for mistrial, because he gave a curative instruction and thought that would be sufficient?
I can't get in the trial judge's mind, but I also know he sat...
Go ahead.
You know, he sat through the whole thing and knows how the trial's going, just like the attorneys did. You know, the attorneys knew how the trial was going. The story of how this happened was so completely implausible that I don't even...
Story of how what happened?
How the man cut his hand.
And so you're going to bring out the fact that he's a drug addict and the fact that he had a prior recovery of $100,000 and some. I mean, that's going to establish the implausibility of how this particular accident happened?
No, he established his own implausibility. He made his own story implausible, which was by filing the complaint and saying it happened one way, answering interrogatory saying it happened another, then retaining an expert, then getting deposed and saying, uh-oh, maybe it happened differently. He made it implausible.
That makes the testimony and evidence regarding this fellow's prior drug addiction and the amount of his recovery in the prior lawsuit all relevant then?
I didn't say it made it relevant. I said it made it harmless.
Harmless.
I would not say it made it relevant. And my trial counsel did not argue, Your Honor, Judge, I get to bring this in because I'm trying to attack his character or prove it didn't happen this way. He had plausible explanations forgive me. Only one time was the issue brought up before it was asked.
I think that this testimony was presented or was elicited for the purpose of prejudicing this jury. I mean, when you take a look at the fact that the amount of the prior lawsuit was introduced into evidence and came to the jury, and then you consider the fact that Lowe's brought out the fact that this man was a drug addict when he was 14 years old. And I don't care how long you've been practicing law. It seems to me that a trial counsel, even if you've got 1 or 2 years experience, knows better than to bring that type of evidence out in a trial like this, unless your motives are to get the jury prejudiced by appealing to their sympathy and their prejudice.
I know with respect to the prior...
I haven't seen a case like this before where this type of evidence came out to a jury and a mistrial wasn't granted.
You haven't?
No, I haven't.
Okay, because I haven't seen it cited in the initial brief as a basis for reversal.
I haven't seen it as a trial judge for 15 years,
Okay.
and in my experience, I've never seen trial counsel try and get this sort of evidence to the jury.
Okay, now I understand where you're going with your
This is a new one on me.
Well, with respect to the prior lawsuit, which is the only thing that was discussed before it was brought in, because we have a motion in limine. Counsel stated the purpose of that, and they did not discuss in the motion in limine the amount, but he did state that he felt the litigation was appropriate because it showed a recovery for an injury that he's now complaining to his doctors about. His subsequent doctors who are treating him for the finger and prescribing these heavy narcotic drugs, their first recollection of a complaint from Mr. Williams is his back, which is from the prior injury, the prior lawsuit, and for which he was compensated.
Do you have any argument that the amount of the settlement was in any way relevant, or are you simply arguing that it wasn't preserved, so we shouldn't get to that?
Do I have any argument the amount wasn't?
Was relevant.
Well,
You're arguing it's harmless error, you're not arguing that it was an error.
I'm not arguing that it was an error. I want to answer this as artfully as possible. The amount may have been a step too far. The amount may have been.
May have been, it was a step too far.
We all agree that.
Yeah.
Okay, well, at least,
It was a big step too far, I think.
What about the cocaine addiction?
what about it? Was
Is
it
that a
error?
step too far and it's just not preserved, so we shouldn't get to it? Or are you trying to argue that that wasn't a step too far? The addiction testimony.
That was, it's difficult because we're arguing he's
Oh, come on.
can I please?
You know good and well it was error for that testimony to come before the jury. I mean, here's a guy that's 14 years old, he's got a drug addiction problem, and she said when he was in his 30s, this lawsuit took place.
Here's why I paused, gentlemen, with all due respect. You all asked me if it was error, so I was thinking, did the trial judge err? The trial judge didn't do anything with respect to the crack cocaine except give a curative instruction. If you're asking me, was it overzealous work by defense counsel? Yes. That was a different story, but you all had asked me, was it error? And that's why I was struggling, because the judge didn't rule on the drug issue.
Was it error by trial counsel to put that before the jury? Let's put it that way.
Error. It was overzealous advocacy. Overzealous advocacy. They were aware of the prior lawsuit. I can't explain why Mr. Faddis was not aware of his client's prior lawsuit. Everybody was aware of the prior lawsuit. I believe it was discussed in the depositions. It was not a surprise that there was a prior lawsuit and there was medical treatment rendered. Trial counsel did not intend to put in those medical records.
Let me ask one other question. A curative instruction was given, and we all know that the motion in limine did not cover the prior addiction of this plaintiff. I assume it wasn't put in the motion in limine because they probably had no idea that anybody would try and get it to the jury. But in any event, it wasn't in the motion in limine. And the evidence came out, and it wasn't objected to at that time. And then sometime later in the trial, and we think the same day, a motion for mistrial was made. And the trial judge said, no, instead of doing that, I'll give a curative instruction, and that will take care of the problem. What if we say that the curative instruction didn't take care of the problem, and that was not enough to fix it? Then what do we do with the court's denial of the motion for mistrial?
Aren't you then just acting as the trial judge or a seventh juror? I mean, the judge, when the motion for mistrial was presented to him, and the motion for new trial.
What my question to you is, I think the argument that I've heard, and maybe I've misunderstood it, that the curative instruction was given and the motion for mistrial was denied. Therefore, we look at whether the trial court abused its discretion in denying the motion for mistrial, right?
Right.
What if we say that the curative instruction was not sufficient? Then do we still look to the discretionary standard? Well, the trial court still didn't abuse his discretion, or do we apply some other standard?
I still think it's discretionary because the motion for mistrial was made before the curative instruction. In fact, that's why he gave the curative instruction, was as a result of the motion for mistrial. So then they give the curative instruction, so you have to determine, if I may go on, that at the time he ruled on the motion for mistrial, was he within his discretion in the ruling he made? I would submit to you that he was. Then when the motion for new trial came out and the judge heard everything, saw the verdict, then the trial judge could decide at that time, did this, preserved or not, was this evidence, these two issues?
If there was a request for a curative instruction in the trial, let's just assume the trial court denied it. So I'm not giving anything, I'm not telling the jury anything, there's no curative instruction. Then the motion for mistrial is made. Is there a different standard that applies for us to determine whether the trial court erred in granting the mistrial? Is it still abuse of discretion? If he had denied the request for curative instruction and didn't give it, do we still use the abuse of discretion standard in determining whether the trial court made a mistake in denying the motion for mistrial?
Judge Suawa, I need to be honest, I didn't research that issue to determine, but my general understanding of motions for mistrial, and most of these post-trial motions, is that it's an abuse of discretion unless some of them should have been judgment in accordance with a motion for summary judgment or things like that. But these motions were related to the admissions of evidence during trial, which are all discretionary acts. I know there are some nuances with respect to a finding of law with respect to whether something's hearsay or not, but this was just letting something in. I'm sorry. Any other questions?
Thank you.
Your Honors, with respect to the argument that the judge was just waiting to hear the context, amount of prior litigation's not relevant, it's never relevant, should never come in. The judge doesn't need to wait.
Did the motion in limine specifically ask about the amount, or did it ask about the prior lawsuit generally?
Prior lawsuit in general. Basically, that everything to do with the prior lawsuit, the fact that there was a lawsuit, a jury verdict, and a judgment be excluded. And the judge said, I agree with the defense, I deny that. Because the defense argued that that was relevant, that the prior lawsuit was relevant. No one was ever suggesting that the prior injuries were not relevant or that the prior injury should not be admitted. With respect to this issue about is it preserved or is it not, and the idea of a mistrial, First District Court of Appeals said in White that the trial court has a duty to grant a mistrial when there is a likelihood that improper comments or evidence influence the jurors, however subtly, in their determination. We clearly have a very strong likelihood of that here. We have a miscarriage of justice in the sense that this plaintiff was in fact denied a fair trial because of these innuendos about addiction to crack cocaine, when he was a teenager, and the amount of the judgment that he received in this prior unrelated lawsuit have so tainted this jury against the plaintiff that he was not able to receive a fair trial, and a curative instruction was simply not going to be enough to fix that. In the Henderson case cited in the brief, the improper admission of evidence concerning a defendant's prior criminal history is frequently too prejudicial for the jury to disregard, regardless of any curative instruction. Crack cocaine use, that's prior criminal history by this plaintiff, and in this case even more damaging, as I've said, because of the argument that he's just lying to his doctors in order to feed a narcotics habit.
Was that argument made? Is that one of the arguments that the other side made to the jury, that he was trying to feed this habit and that's why he was getting these pain pills?
Your Honor,
or is it an implication that you're raising?
That was insinuated in the closing argument. Yes, it was, by defense attorney, that you question, why is he really going to the doctor? Now, the defense attorney did not specifically refer to him being an addict in the closing argument, but there was an insinuation that he was faking his pain in order to get prescription medicine, which clearly relates to this prior evidence that had come in about crack cocaine addiction.
Would that have been a legitimate argument had they not had the information about the prior crack addiction? I mean, would it have been fair comment for defense counsel to say, look, he's not really hurt that bad. He's just, he continues to go to the doctors mainly to get the medications.
It would be fair argument, Your Honor, if there were admissible evidence to support that argument. If a doctor had said, in my opinion, he's just trying to get prescription medication, or in my view, his finger is not causing him pain. But there was nothing to suggest that his complaints of pain were faked other than the improper evidence that came in about the crack cocaine addiction. And let me just speak very briefly to fundamental error, if I may, since there's a huge concern, obviously, by this court and a huge argument by Lowe's that these things were not all preserved. Fundamental error is error which deprives a party of a fair trial, or an error which objection or a curative instruction could not correct. That's from the 4th DCA in Cordoba. The Florida Supreme Court in Sanford said fundamental error, which can be considered on appeal without any objection in the lower court, is error which goes to the foundation of the case or the merits of the cause of action. So it's the plaintiff's position that, in fact, that's exactly what this did. It did go to the merits, because the critical...
Well, it went to damages.
I beg your pardon?
I thought these issues involving drug addiction and the prior lawsuit all implicated damages, not liability.
Your Honor, Lowe's position was that it implicated the plaintiff's credibility, and his credibility certainly went to liability, since he explained how the accident happened, that this thing flew off the saw. I see the judges are getting restless. May I have leave to conclude? I certainly would not want to wear out my welcome. The plaintiff would respectfully request that this court reverse for a new trial on all issues. Thank you.
Thank you, counsel. Thank you.